So good afternoon and welcome to the 2012 TARGETjobs National Pupillage Fair and to this talk on family law. Delighted to welcome our four speakers for this afternoon. We have Laura Moys at the end from 1 King's Bench Walk.
Hello.
We have Amanda Sheridan from 29 Bedford Row, Matthew Brunsdon Tully from 1 Hare Court and Nick Westley from QEB. Now firstly, can I just ask that everyone turns off their phones please, because obviously due to the camera equipment we are recording it this year. Obviously in previous years we've had to let students down because we just obviously can't fit the numbers in the room. So we are recording the talks, they will be put on our YouTube channel and also on TARGETjobs website from Monday morning. So if you've missed any talks today or you'd like to recap this one, please do go online and have a look at that. So that's why we do need your phones off, I'm afraid. So our four speakers will be spending about 10 minutes each just talking you through family law and sort of what you can expect and how to get pupillage, things like that. Do hold any questions to the end. I'm hopefully going to be able to open the floor to questions for about 10 minutes at the end. So if you do have any questions, that will be the time. So if I can invite my speakers.
My name is Nick Westley. I'm from Queen Elizabeth Building. I was called in 2005 and I practice exclusively family law with particular emphasis on financial proceedings. I'm going to talk a little bit about how I got into family law and why I particularly find family law interesting, and then our other speakers will talk about slightly different topics so we are not repeating ourselves. I think my interest in family law, or my interest in the bar I should say, stemmed initially from being a rather argumentative and difficult teenager, and it suddenly dawned on me during one dressing down that there was an opportunity of exploiting skills of being argumentative and difficult, and actually there was a career that could put those skills to good use. I'm not being facetious when I talk about being argumentative and the skills that you need in arguing as being useful to a career at the bar. It's actually a necessity in the sense that if you're the sort of person that doesn't like conflict and avoids those types of situations or is a bit of a wallflower, then perhaps the career at the bar is not the career for you, and it certainly is a career in which you need a bit of a thick skin, and certainly Matthew will be talking about the skills that are useful to a career at the bar a little bit later on. My interest in family law only really arose during university, and as most of you that have studied law or that will study law will find out, is that family law is not taught as a core subject as a university, as a law degree subject, or even on the GDL, and is often optional. And therefore a lot of people, either it completely bypasses them or they discover it at a very late stage. But for me there were two key aspects of family law that I found particularly interesting and exciting when I finally got around to studying it at university. The first of those is that as an introduction to the subject, it's one of the easiest subjects I found to get into, in the sense that when you are taught about trusts or tax or land law as a student or as a young adult, not a lot of us are particularly familiar with the sorts of issues that arise in those sorts of cases, whereas families are a concept that are familiar to all of us. We all have a family, and it's quite easy to familiarise yourself with the sorts of situations that arise in family law. It's also a subject that often people have quite passionate views about. It's quite difficult to get excited about whether or not the doctrine of consideration is a good or a bad thing in the law of contract, but people have slightly stronger views about the idea, for example, such as gay marriage, about whether or not wives receive too much on divorce. These are subjects that are actually a little bit more interesting and people have a bit stronger views about. The other area that I think is particularly exciting about family law is that when you look at the sorts of cases that the cases that we regularly refer to when we are in court ourselves, they're all relatively recent decisions, and that's interesting to me because it shows that family law is a very relevant subject, in that the law changes and is a lot more fluid than perhaps other aspects of the law, in that when you're studying trusts, for example, or contracts, you're applying principles that were set down maybe 100 years ago, and not a great deal has changed since then. Whereas family law changes very rapidly and changes much more quickly in accordance with changes in society's norms, and so even in our very brief careers, we can point to quite seismic changes that have taken place. And the reason I think this is interesting is not just does it make the law more relevant, but actually as barristers who are involved in the law, it gives us greater scope to feel as though we actually have active involvement in changing and shaping family law as it is today. All of us on this table have been involved in reported cases, and therefore by their very definition, we have had some small impact in changing or shaping the law in this country. Amber last year was involved in a very big case in the Supreme Court, whereby the Supreme Court completely reversed one of the previous decision of the Court of Appeal. And so we can actually say that we have active involvement in changing the law and shaping it, which certainly I think makes our job more interesting. Don't take my word for it, though, as to how interesting and exciting family law is. The best bit of advice I think I can give anyone that's interested in a career in this aspect of the law is to go and undertake some mini pupillages. And a lot of people undertake mini pupillages, in my view, for slightly the wrong reason. I think the temptation is when you know that you've got a complicated form to fill out and lots of interviews to undertake, the temptation is to do mini pupillages so that you've got useful things to talk about in those interviews or to put on your application form. In my view, that's completely the wrong way around. You should use mini pupillages as a tool for yourselves for this reason. When you study law as an academic subject at university, there are subjects that you may find absolutely fascinating and hugely interesting, and you think, this is the career that I want to pursue. Often the practical life of pursuing a career in that area of the law is very different to the academic study of the subject. For example, criminal law I studied at university, and the way it was taught to me was it was presented as though, as a criminal lawyer, your role is to defend the rights of the poor, oppressed individual from the evil machinations of the state, which is perpetually trying to restrict everyone's human rights and restrict people's liberty. All very worthwhile and interesting and exciting stuff. When I actually did a mini pupillage, I found that I spent an enormous amount of time kicking around in magistrates' courts, waiting to get into court, which rarely happened because the system was so chaotic. The clients that you met were rarely the poor, oppressed, innocent individuals that were being pursued by the state, but they were repeat offenders that you were spending much time getting off on a technicality. And then there were lots of other aspects of the job, such as the really abysmal pay, that you just have no appreciation of when studying the subject as an academic subject until you actually go and do a mini pupillage. And so I can't recommend more strongly the idea of going and using the facility of the mini pupillages. Similarly, even when you've decided, yes, I know that I want to study family law, or a particular area of family law, again, I can't advise strongly enough to go and try and do mini pupillages at different sets within that particular area. The reason being is that, as all of you will have found when you apply to universities, for example, to study law, each prospectus says, we are a really great university for doing this subject, we're academically fantastic, we're friendly, we've got lots of facilities, come and study with us. And in exactly the same way, each of our respective sets will say the same to you as to why you should apply to us for pupillage. We're all from extremely good sets, but their nature and their characters are slightly different, in exactly the same way that you can have equally good universities. Some maybe have a particularly sporty bent, others have a particular focus on different areas, and it's really not until you actually come and do a mini pupillage that you can experience what the character of these different sets are like. And it's absolutely vital, because the ultimate aim of you applying for pupillage is that you're going to get a tenancy. And if you get a tenancy, effectively, short of you committing some heinous crime, you've got a job for life. And we had an unfortunate situation a few years ago where someone applied for pupillage, got a pupillage, they really impressed us, but partway through the pupillage they realised, I'm not sure family law's for me. Now, you have to jump through so many hurdles and hoops to get to the stage of getting a tenancy. The last thing you want to do is achieve that and think, maybe this isn't for me. And so mini pupillages, in my view, are the best way of actually getting the practical experience of what life at the bar is really going to be like. And the only other bit of advice I've got, if you haven't done it already, I'd strongly recommend coming and seeing the QEB stand, which is in the main hall on the right-hand side, just as you come in.
Hi, I'm Matthew Brunsdon. I'm a barrister at Hare Court. I've been practising since about 2008, and my practice is also exclusively in family law, predominantly in financial matters, but I do probably about 30%, 40% children work as well. I'm going to talk to you about the skills needed to have a successful practice at the family bar. Perhaps starting with the bar in general, it's really important, I think, that you have integrity. I was speaking to a silk over lunch yesterday who was recounting a case that he did about 20 years ago, where he argued one side of the case, and because the other side was in person and didn't look as if they really understood what was going on, he proceeded to argue the other side of the case as well. I don't think he got any work from that particular instructing solicitor ever again, but I think it's a really good idea of what the bar is about. It's about doing things the right way and about educating the court as well as fighting hard for your client. So I would say integrity is the most important thing. Judgement is really important. That's something that we were discussing on our stall before I came here when I was asking, what's the most important quality. judgment was said to be probably the most important one. In particular, in what we do, if you're in a financial case, for example, and you're working out how to divvy up assets on divorce, judgment is really important because the area of answer relief, or financial remedies as it's now called, is so highly discretionary based. The judges have a very broad ambit, and so really the outcome that you think is likely is going to depend quite heavily on A, which court you're in, B, which judge you've got, and actually probably that's even more important sometimes than the actual your understanding of the case and what the law is. And you will often ring around chambers and say, anyone got experience of this particular judge? What do you think they're going to do? Are they a husband's judge, they're a wife's judge, they're a mother's judge, or a father's judge? I probably shouldn't say that because I'm being recorded, but there we are. So really important judgment. Obviously persuasive skills really important as well. I agree with Nick. That sounds like something that somebody else has said. I agree with Nick that being persuasive is really, really important. But some people do have practices, probably at the family bar, without being particularly persuasive. I know that sounds a bit odd, but actually numeracy is really, really exceptionally important doing financial remedy stuff that we do. And sometimes you can get by without being particularly persuasive, but by being thought to be right more of the time than not. So persuasive, yes, but other skills really important as well. So numeracy, ability to construct a good written argument as well as an oral argument. Dealing with people, obviously, as well. I mean, you get to court more often than not, and your client is quite distressed. Whether it's a children matter in particular. Say you're acting for a mother. I did a case last year where I was acting for I remember it really well, really, really vividly, a Latvian mother who had abducted her 3 children to this country, and there was clear evidence of domestic violence back in her home country, and ultimately, the Hague Convention is pretty clear. She had to go back. There wasn't enough evidence in the case to suggest that the Latvian state couldn't protect her. There are the limits.
Could you speak up a little bit?
Sorry, yes, of course, I'll try. The defences under the Hague Convention are very limited, and so being able to, in a sense, help her through that process was arguably more important than the law in that case. And so actually, even though we knew that we didn't really have much of a defence, the key aim for us as her representation was to effectively delay the proceedings to such an extent that she was able to come to terms with the fact that she was going to be going home. So dealing with your client, helping them, really, really important. Dealing with the other side, really important too, because in the end, a lot of what we do is about negotiation, not just about what you're doing in court. It's about trying to come to an amicable solution with the other side. When you get to court, for example, in a financial case, you'll touch base with the other side as soon as you arrive at court, and say you're doing what's known as a financial dispute resolution hearing, which is a hearing where you basically raise the arguments that you would raise at trial in front of a judge and get an early view about what's going to happen in the case. The first thing you really do is touch base with the other side and try and settle the case. And then as soon as the judge has given you an indication, you'll come back out and sometimes spend the rest of the day at court negotiating with the other side. And so really that 20 minutes, and perhaps even less, that you have in court, whilst an important part of the day, is really just a very small part of the day. And more important is the strength of your negotiations and those kinds of skills, dealing with the other side during the day and, hopefully coming to a solution. All sorts of other skills. I mean, ultimately at the bar, I think probably the last thing I'm going to suggest is that you need to have the ability to cope on relatively little sleep sometimes and be quite sort of a decent fortitude, if I can put it that way. For example, I was in court on Friday morning in an ex parte abduction case. Then on the afternoon at 2:00, I had a telephone hearing in a different matter. I had to give a talk. I've also got a 3-day trial starting on Monday. Basically, I'm not going to be sleeping much tonight or tomorrow night. I'm going to be driving to Cornwall where I'm going to be doing my case. And I think that's not unusual. I'm not saying that to sort of sound grand. It's really not grand at all, getting up at 4 a.m. and getting into chambers at 5 a.m. It's actually pretty grim, and you will feel pretty rubbish a lot of the time. But it is all worth it when you win the case.
I am going to talk about a week in the life of a junior family barrister. And the first thing I should say is actually there's no such thing as a typical week in the life of a junior family barrister. Matt's just given you a flavour of what his next couple of days are going to involve. And I thought it would be useful because, as Nick has said, if you've studied family law already, it will most likely have been from a pretty academic perspective. And even I found on the BBC, as it was when I did it, that even though the practical sides of things were looked at, you don't have enough time on that relatively short module to go into any detail about the types of hearings that you might do and what they will involve. And I think it's right that if you are specialising in family law, Nick and Matt have said how their focuses of their practices are primarily financial. That's probably the same for me, although at the junior end of Bedford Row we do have perhaps a slightly wider range in terms of children and money, which then focuses a bit more as you go on. But you will need to know about the different types of hearings that you go to, and that actually, from your perspective, when you're applying and when you're doing your mini pupillages, and then if you're getting interviews, it's a really good idea to know about the practical side of things rather than just, I want to do family law because I want to help people. Because that's a pretty standard response. And if you can be more specific and say that you've seen types of hearings and what those hearings have achieved or what they haven't achieved, then that, in my view, would make your application stand out. So let's imagine Monday, just so we're nice to ourselves, we'll have an afternoon hearing. So we get Monday morning to ourselves, which is always quite nice because then you don't have to work on Sundays, which I invariably find myself doing probably 3 out of 4 weekends a month. So a Monday afternoon hearing, and again, it's in London, so we don't have to worry, it'll be in the registry. And it's a conciliation hearing in a Children Act matter. So that is the first hearing that you would have in an application by a parent for contact, perhaps, or residence, but let's say contact in this case. You turn up to court, say an hour before the hearing at 1 o'clock, and you go and sign in, and you see, as you will be seeing, and as we see more and more now, that the other side, the father, isn't represented. He's representing himself. You've produced a short note for the court to help the judge. So the first thing you would need to do would be to go and find him and explain who you are, what your role is, give him your documents if you have them, and explain to him that it's not right that he should have had them days before, and that if there's anything in there to ask you to explain concepts or principles that you might have set out in that document. Now, dealing with self-represented parties, which is I think what we're supposed to call them now, because is generally litigants in person was the old phrase, and I think there's a new vernacular coming in. So self-represented parties.
In New Zealand they call them querulants.
Why, really? That is a skill in itself. And when Matt said you've got to be able to deal with people, dealing with an individual that's representing themselves, especially in a children case, you can imagine it is probably one of the most stressful things they've ever had to do, unless they are perhaps a lawyer or have a job which involves a lot of conflict resolution, then it's likely to be a terrifying experience for them. And quite often, people who are worried about situations, that will come across as being very defensive and sometimes aggressive. And you've got to do your best to minimise that, because in the same way that Matt said that the FDR hearing, the financial dispute resolution hearing, a lot of it is about negotiating with your opponent. That's very similar in this type of children case. Now, it might be that in this case, all we're arguing about is whether it's 3 hours on a Saturday for the father to see the child or the children, or 5 hours. So there we've got a relatively small area for negotiation, and we can focus on that. In other cases, it's a lot more significant. It might be that your client, the mother, says she doesn't agree to any contact at all. She has real concerns about the father's ability to look after these children when he has them, and says that either there should be no contact at all, or it should be in a centre where it's supported or it's supervised. So you will have to spend the afternoon trying to narrow the issues as much as you can, get some assistance from the judge, and very often if you're against somebody who's representing themselves, unlike if you are against either a solicitor or another barrister, there's very often a common understanding as to where a case is going. If you're against somebody that's representing themselves, they're unlikely to want to engage very much with you before the judge has given his or her view. So that's Monday afternoon. So you finish that maybe at 5 o'clock, emotionally drained. And what was that?
Just say it's going to be a long week.
It's going to be a long week. I'll speed up. We'll put a prep day in somewhere. That'll go very quickly. So Monday afternoon, very drained. But you've got, the next day, you've got to travel up to Worcester, say, for a first appointment in a money case. So you've got to go back to chambers. You've got to make sure you've done all the prep you needed to do. This takes me to the next point, Tuesday morning. You've got to be pretty good at A, travelling, B, knowing your way around a train timetable, and C, actually having some sort of sense of direction. Now, that for me is my weakest point. I'm hopeless. So get the National Rail app on your phone. Make sure you've checked the train times before, and you can check them again in the morning, because the number of times you get to the station and things aren't quite as they seem the night before on the internet, it's terrifying. So that's something that really is important. You are aware of the practical side of things. And again, when it comes to applications, it's useful if you don't just know about what you might have to argue in terms of principles of law, but you know that as a junior barrister at the sets perhaps that we are here to represent, you will have to do a bit of travelling. A lot of our work is based in London, but a lot of it is in the surrounding area, and sometimes up to Leeds, up to Birmingham or Manchester. So you've got to be able to be willing to do that and show that that's what you know that's what it involves. So you go off to do your first appointment. Quite often these can be short hearings. You might have all agreed the questions that are going to be asked by each side at the initial stages of your of the financial application. It might be that you're at court all day. So again, you can't make any plans to meet somebody in the afternoon for a coffee because you're up, where were we, in Worcester. So you've got to make sure you've got a flexible...
the wrong train.
Yeah, I've done that. So you've got to make sure you've got flexible arrangements. Again, the number of times that I have had to cancel dinner plans or going out to the theatre because a case is overrun and I'm stuck somewhere and I know I won't get back till 8 o'clock, that's another consideration. You've got to be able to be flexible about things. So Wednesday, let's have a prep day. That'll go quickly. And that prep day is for your 2-day final hearing on Thursday and Friday. Now, this 2-day final hearing, let's say it's a money case, but you have to go to court and your instructing solicitor, and again, this very often happens at our level, will say, well, look, the client's really concerned about how much this is costing. And actually, I can't, they don't want me to send a representative or even send the solicitor themselves along to court. So you might have to do a 2-day final hearing in a financial matter without any backup. So you've got the client. And it might be that the client hasn't met you before. It would be ideal if they had, and you'd had a con perhaps before, and you'd been able to speak to them. But sometimes you don't have that luxury. And if you do legal aid work, which certainly I do a small percentage of it at Bedford Row, again, the Legal Services Commission may not provide funding for a con before a final hearing. So you turn up to court at, say, 9 o'clock. You've got an hour or so to get your client on side and understand where they're coming from, and explain to them what the parameters of your role is going to be. Again, it may be that the client you have has certain, or the relationship that you need to develop with the client has certain difficulties that present itself at court. I've had a case recently in a children matter where I didn't have a solicitor with me, and my client had quite severe Asperger's, and the way in which I had to take instructions and give advice, I had to adapt significantly to take account of that. And that is something that you don't obviously have any training for when you're doing your BBC, and you've got to be able to take the situation that's thrown at you, sort of and face it head on, and deal with it in the best way you can. So we've got to Friday, and I'm going to stop because we're running out of time.
I'm really sorry.
Hi, I'm Laura Moys, and I am 2008 call, and I'm at 1 King's Bench Walk. And I'm very conscious of my call because it's not really all that long ago. And looking out at you all today and having spoken to several of you that I recognise from coming over to the 1KBW stall earlier, I'm very conscious of the fact that I was in your position really not very long ago. And so I know that the most burning question in all of your minds, irrespective of all of the very helpful information about being a barrister and the day-to-day life and grind of being a barrister, what you really want to know about is how are you going to get a pupillage, and that's, let's face it, that's what you're all here for. And I was reminded of how close in age and in experience to all of you that I actually am when somebody accused me of queue jumping on the way in here, and I had to point out that I was actually giving the talk, believe it or not. But one of the questions that we were asked a lot on our 1KBW stall this morning was, what should I say on my application form that makes me stand out as a family barrister? What's going to get me an interview and what's going to get me a pupillage? And I would say that the first thing that you have to remember is that sometimes in your haste to cover all of the different elements of that form, your academic qualifications, your mini pupillages, your work experience, you forget that the application itself is a form of written advocacy. And so when we read your form, we want to see that you write beautifully, that you are able to sell yourself, because as my colleagues have said this morning, a lot of family advocacy is about negotiation. It's about the note that you've given to the judge before you go in. It's about scaring your opponent with what you've put in there, or perhaps that's just me fantasising about how scary and brilliant my notes are. And so remember that it's not just the content, it is the way you sell yourself, and it's the way that you write. It's also about having a common sense approach. Family law, in as much as one of the things that I love about family law is the breadth, is the fact that it's changing all the time. Ultimately, somebody comes to see you. They haven't got all the money in the world to be arguing really interesting points and going off to the Supreme Court. They want to talk to you about their relationship that's broken down. They don't know what they should do. They've probably got lots of different areas that are affected by that relationship breakdown, and they want you to give them a common sense, rounded answer to their questions. And so don't forget, when you're filling in your application form or applying on the pupillage portal, that the other aspects of your life, those skills that maybe you don't naturally think are things that you would include on your form, if you can utilise those and demonstrate how, in fact, they will give you the skills that are necessary to be a barrister, then that's something that would really impress me. So, for example, you might not think that the fact that you've had to work all the way through university to afford to pay the fees, it's not something you might naturally think of putting on your form. But if the job that you've done is working with members of the public, you've had to deal with lots of different people, perhaps people who are anxious when they come to see you. I worked at Boots when I was at university. I worked in the chemists at Boots. And so not only did we have people who were in a rage because they'd had to queue for however long to get to the front and pay, but people who had questions for you, perhaps sensitive or embarrassing things that they needed to ask you. You had to deal with people from all different backgrounds, perhaps very different backgrounds to yourself. So don't forget that general day-to-day experience of life is something that is incredibly important as a family barrister. Even just things like, I did French as my degree and then did the conversion course. And so I lived abroad for a year, and I had to go in France and manage to set up a bank account, which, if anybody has any experience of French bureaucracy, is not the easiest thing in the world. And so, again, you're going to be asked by your clients, somebody at the council are going to evict me from my property. Okay, you're not a property lawyer, But what they don't want you to say is, oh, well, I'm terribly sorry, but I'm not a property lawyer, so I can't help you. You're going to have to go somewhere else. They want you to use your brain, use your common sense, and be able to apply that. So remember that. Also remember that family law isn't just one discipline. Again, when I was asked about family law, and I was asked what I did, and I said I was a family lawyer, somebody said to me, and I think it was at a wedding, and this may have been why they said it, said, oh, so you divorce people, and that's what you do. I thought, well, maybe I should say it a bit quieter given where I am. In fact, family law isn't just about matrimonial. You've heard that some of my colleagues specialise in general terms in what we call money work or finance, dealing with the assets of a family on divorce or separation. Of course, there's also children work, you'll hear it said, but that encompasses both private law, which is disputes between parents about, once they've separated, contact with children, for example, but it also covers things like adoption and surrogacy. There's then public law children, which is where the state intervenes in family life. And so remember when you're applying that not every set that does family law perhaps does the particular area of family law that you may wish to do. There's no point applying to Hare Court, for example, if what you really, really want to do is public law children with a human rights element to it. That's not the set for you. And so you do need to have a think about the area of family law and make sure that your application form reflects, as well as you can, that particular area of expertise and is tailored to the right set. I think it's also important to remember that family law, and I'll stop in a moment and open the floor to questions, but I think the final thing to remember if you're looking to do this job is that family law, perhaps more than any other area of law, is not a business transaction. When you're giving advice to your clients, particularly in a financial case, it may be quite obvious what the answer is because there are no assets and one of the parties requires, for example, because they are housing 3 children, requires almost all of the assets to enable them to meet that family's needs, and the answer is obvious. But what you have to remember is that your client may wish to spend more money than they have arguing about something where the answer is obvious, because you are dealing with somebody who has just come out of their most bitter, acrimonious breakup. And so you've got to be able to cope with the fact that it isn't about pure law, it is about getting people, as has already been said, through that process, having empathy and being able to offer common sense, sensible, practical advice to people who are in an incredibly difficult situation. Because family law and criminal law are really the aspects of law that most people will come across in their lives. Most people don't get involved in complex trust disputes, but lots of people get divorced and lots of people have family problems. And so it's really about that common sense approach, and that's what I would urge you to remember when you fill in your form.